Hello everybody, welcome to iExamB. This is Amrita, your law faculty, and I am here with a very interesting and important video relating to Arbitration and Conciliation Act. But before we start with the discussion, don't forget to subscribe to LegalBee and stay updated with all such kind of interesting and very important content, dynamic content that we keep on bringing relating to law, various legal exam preparations, legal concepts, doctrines, maxims, and whatnot. So don't forget to subscribe, and also you can write to us at hello@iexamb.com. In case आपके कोई queries हैं, आप इस नंबर पर भी कॉल कर सकते हैं, and you can also visit the website www.iexamb.com for more details relating to all the legal courses that are available. So starting with the discussion, आज का जो वीडियो मैं आपके लिए लेकर आई हूँ, that is actually, as I told you, dynamic, because it is relating to the changing and the amendments that have been carried out, the key features of all amendments made to Arbitration and Conciliation Act 1996. This is going to be a very comprehensive video, and in this one video we are going to study all the major amendments to this act. 1996 Act is the principal one, but it has been amended thrice till date. तो उसके कुछ फीचर्स हैं, की फीचर्स, वो हम लोग डिस्कस करने वाले हैं. एंड और इस वीडियो की डिस्क्रिप्शन में आपको पीडीएफ भी मिलेगा. यू कैन डाउनलोड द पीडीएफ एंड गो थ्रू a more brief notes of that particular topic of all the three amendments, and also you can download the PPT of this particular video for your future reference. Alternate dispute resolution system के बारे में थोड़ा डिस्कस कर लेते हैं. What is it? ADRS. This is actually a very growing field now. ADRS, alternate dispute resolution system. ट्रेडिशनल लिटिगेशन के कुछ डिसएडवांटेजेस की वजह से, स्पीडी डिस्पोजल नहीं मिलने की वजह से, एंड ADRS इज समथिंग विच इज कॉस्ट इफेक्टिव एज वेल. You can settle your disputes out of the court. That's why this is growing a lot day by day. There are many advantages. You can resolve the disputes out of the standard court procedures. It is a speedy mechanism, and this is the reason that it is gaining more popularity than even litigation nowadays. Litigation can never end, but still there is a marked shift. I would say there is a marked shift towards ADRS from litigation now. It is constantly growing field, especially in case of arbitrations for commercial transactions, for labor disputes, contractual disputes. You will find a lot of arbitrations going on. International commercial arbitrations can be a very good example of that. So ये सब जो है इंटरनेशनल कमर्शियल आर्बिट्रेशंस के लिए भी हमारे कंट्री ने जो ये अमेंडमेंट्स लाए हैं, बेसिकली यू विल फाइंड आउट, इज टू प्रमोट दीज इंटरनेशनल कमर्शियल आर्बिट्रेशंस एंड फ्रॉम दैट encouraging ultimately foreign investments. So that is why it is important to study all these three amendments as well and know how it is developing constantly. There are basically three amendments to the principal act. Arbitration and Conciliation Act will remain the principal act. All the major provisions which are still followed of 1996 Act as only. It has been amended majorly in 2015. आफ्टर दैट 2019 में कुछ अमेंडमेंट्स आए थे, एंड देन 21 में कुछ आए हैं. बट आई वुड सजेस्ट कि 19 और 21 को थोड़ा ध्यान से पढ़ना. जैसे 19 के कुछ प्रोविजंस है जो 21 में रिमूव हो गए हैं. दैट ऑल्सो आई विल टेल यू इन दिस पर्टिकुलर वीडियो ओनली. सो टेक केयर ऑफ दैट एंड नो व्हाट इज द करंट सिचुएशन फॉर दैट पर्टिकुलर प्रोविजन, वेदर इट स्टिल एग्जिस्ट्स और नॉट. Amendment Act of 2015 has focused on making India a hub of international commercial arbitration, and for that it has amended the definition clause itself of court under section 2 clause E of the act, that only a high court can exercise its ordinary original civil jurisdiction in case of international commercial arbitrations. So the jurisdiction itself has been decided and it has been amended that only High Court has power to do that in case of international commercial arbitrations. Then arbitration proceedings are going to commence after obtaining an interim order of the court, and for that they have applied a time limit जो पहले नहीं था. टाइम लिमिट्स क्यों इम्पॉर्टेंट है? बिकॉज अल्टीमेटली जो ऑब्जेक्टिव है, जो ADRS का गोल है, दैट इज स्पीडी डिस्पोजल. So for that it was necessary to have stringent timelines which 2015 Act has added. 90 days के अंदर interim order के बाद 90 days के अंदर arbitration proceedings commence होनी चाहिए, and if there is an application to set aside an arbitral award, then for that also disposal के लिए एक टाइम लिमिट दी गई है. विद इन 1 year ऑफ फाइलिंग डिस्पोज ऑफ हो जाना चाहिए आपका मैटर इफ इट इज रिलेटिंग टू सेटिंग असाइड ऑफ एन आर्बिट्रल अवार्ड. नहीं तो क्या होता था कि आर्बिट्रल अवार्ड्स पास हो जाते हैं बट उसको सेट असाइड करने के लिए एप्लीकेशंस दिए जाते हैं एंड वो एप्लीकेशंस को पेंडिंग रखा कर जाता है एंड अल्टीमेटली द ऑब्जेक्टिव इज नॉट बीइंग फुलफिल्ड. सो दीज अमेंडमेंट्स आर देयर फ्रॉम दैट पर्सपेक्टिव. Completion of arbitration proceedings should be done within 12 months from entering into a reference. So even the proceedings should be completed in 12 months whenever the reference for arbitration has been entered into. And then there should be fast track arbitrations. Fast track arbitrations is a very interesting topic. I would suggest you to go into details for that purpose. Fast track arbitrations में यहाँ तक कि oral hearings को भी omit किया जाता है. You can, as I'm telling you, you can download the PDF which is there in the description link of this particular video. उस PDF में आपको काफ़ी सारा डिटेल मिल जाएगा and still it is brief only. Even the oral hearing is omitted. Written pleadings के basis पर fast track arbitrations complete किए जाते हैं. Around 6 months में complete हो जाता है. So that is really fast. Coming to Amendment Act of 2019. It is actually relaxing some of the stringent time periods that have been provided by 2015. That is why I am telling you that these 3 amendments you have to study together. कुछ provisions हैं जो 2015 के 19 में relax किए गए हैं, कुछ 19 के हैं जो 21 में remove किए गए हैं. So you have to take care of that and take note of that. That the completion of arbitration proceedings जितने भी टाइम पीरियड्स हैं उनको स्टडी कर लो एंड उनको कुछ एक्सटेंट तक रिलैक्स किया गया है 19 में. दैट यू हैव टू रिमेंबर. एंड इट इज़ ऑल्सो फ्रीइंग द इंटरनेशनल कमर्शियल आर्बिट्रेशंस फ्रॉम अ प्री डिटरमाइंड टाइम पीरियड. दैट इज it is retaining a provision for completion within a period of 12 months, but that has to be from the date of completion of pleadings. Now जो पहले था from the completion of filing अब हो चुका है from the date of completion of pleadings. So this much change and this much kind of relaxation they have tried to bring in 2019 Amendment Act. Confidentiality has to be maintained in arbitration proceedings. ये एक relatively new concept था which was introduced in arbitration proceedings as well. Conciliation में ये पहले से था but arbitration proceedings में 2019 के ऐड ने ये काफ़ी हद तक establish किया है. Then Arbitral Council of India has been established. So this is an interesting and an important, I would say, feature of 2019 amendment is Arbitral Council of India. You can read the provisions as well for that purpose. And uska constitution hoga as a chairperson, chief executive officer will be there and various other members will be there. What is their job? They have been actually given some powers relating to grading of arbitral institutions, maintaining these arbitral institutions, recognizing their professional institutes which will actually accreditate the arbitrators. जो आर्बिट्रेटर्स की क्वालिफिकेशंस है उस पर काफ़ी ध्यान दिया गया है 2019 के एक्ट में. दैट इज़ वाई आर्बिट्रेशन काउंसिल ऑफ इंडिया इटसेल्फ हैज़ बीन एस्टैब्लिश्ड दैट विल लुक आफ्टर दिस पर्टिकुलर accreditation of arbitrators. Then only we will be getting a quality arbitration in the country. And maintaining a repository for arbitral awards that are made in India, etc. Coming to Amendment Act 2021. 2021 has brought about some key features. So I'm just talking about the very important ones, and the major one is that it has removed the 8th schedule and has substituted section 43J of the act. अब ये जो चेंजेस आए थे ये 2019 के अमेंडमेंट के हैं जो 21 ने चेंज कर दिए गए हैं. 8 शेड्यूल तो पूरी तरीके से रिमूव हो चुका है एंड दैट इज टॉकिंग अबाउट द क्वालिफिकेशंस ऑफ एन आर्बिट्रेटर. यहाँ से क्वेश्चंस आने के चांसेस होते हैं एग्जाम में, सो बी वेरी क्लियर विद दिस एस्पेक्ट कि 19 में क्या ऐड हुआ था एंड 21 में क्या रिमूव हुआ है. सो प्लीज फोकस ऑन दैट पार्ट. इन द PDF it has been explained very well. Go through it. Even this PPT you can keep it for your reference and for your revision. 21 amendment is actually the third amendment to the Principal Act, and that too in a very short span of 6 years. So that is why these three amendments are very important. And presently the position is that the parties are free to appoint their arbitrators from any domain, irrespective of their educational and professional qualifications. This freedom has been reintroduced by the 2021 Amendment Act. क्वालिफिकेशंस पर काफ़ी जोर दिया गया था 2019 अमेंडमेंट में, बट दैट हैज़ बीन रिलैक्स्ड एंड द पार्टीज हैव बीन मेड फ्री टू अपॉइंट द आर्बिट्रेटर्स. ओनली रिक्वायरमेंट इज दैट इट विल बी बेसिंग ऑन द मॉडल लॉज एंड गाइडलाइंस ऑफ UNCITRAL. What is UNCITRAL? United Nations Convention on International Trade Law. तो उस पर बेसिंग कुछ गाइडलाइंस को फॉलो करते हुए ही आर्बिट्रेटर्स को अपॉइंट किया जाएगा, स्पेशली ICA में. बट फ्रीडम कंपैरेटिवली प्रोवाइड किया गया है टू अल्टीमेटली प्रमोट इंटरनेशनल कमर्शियल आर्बिट्रेशन. इंटरनेशनल कमर्शियल आर्बिट्रेशन पर इतना ध्यान क्यों दिया जा रहा है? बिकॉज वी वॉन्ट मोर एंड मोर ऑफ commercial transactions internationally, we want foreign investments, and we want to grow internationally. So the amendment allows, and also the next feature is automatic stay on enforcement of any arbitral awards will be allowed automatically. This is actually a very important feature of 2021 Act. If suppose the court is finding any clear evidence that award is influenced by some fraud or corruption, then in that case the stay can be automatically allowed on the arbitral awards. तो स्टे के लिए ज़्यादा स्ट्रगल नहीं करना होगा, बट द क्राइटेरिया इज दैट द कोर्ट शुड फाइंड अ क्लियर एविडेंस फॉर दैट पर्पस. दिस हैज़ बीन प्रोवाइडेड अगेन इन द 2021 अमेंडमेंट एक्ट. सो ये सब जो भी कॉम्प्रहेंसिव डेटा मैं आपको प्रोवाइड कर सकती थी, जितना ब्रीफ मैं प्रोवाइड कर सकती थी, आई हैव डन इट फ्रॉम माई साइड. You can also take use of the PDF, the PPT of this video and make your own notes. And also you can write to us in the comment section of this video अगर आपको और भी कोई कंटेंट पर कोई conceptual clarity की ज़रूरत है. We have iExam expert faculty for legal, me, myself Amrita Johar, Miss Neha Dubey and Miss Vidika Bansal. We are experts in various subjects of law. And you can write to us at any time at iExam, and also you can write in the comment section of this particular video. Also, don't forget to subscribe, your one-stop solution for all legal exams, that is Legal B. All the mock tests as well are free at iexamb.com. Unfold all your potentials with iExam, and don't forget to subscribe as we help you prepare 50% faster with iExam. Thank you so much, everybody.